parties who sign deals and contracts with you and your government expect that you and your government will keep your word on those contracts?
We continue to negotiate to ensure that they have the rights associated with collective bargaining, and we as an employer have the right to free and open collective agreements as well.
Sorry, that's not the question. The question is, should people who sign a deal with you expect that you will keep your word?
We fulfill the obligations of our contract. We're in negotiations now on a new contract.
The obligations of the contract say that the Crowns have a right to arbitration, and you are taking that right away from them before you've signed a new deal with them. In what way are you honoring the obligations of a contract you signed?
The collective bargaining says that every employee needs a right to be able to ensure that they can exercise if they disagree with the employer. We're providing that to them with the issue of the right to strike.
But Premier, that was not the guts of that contract.
The contract is over. We're on to a new contract.
The contract's not
So
over.
the framework agreement runs for 30 years starting in 2016. The framework agreement is specifically what the Crowns are saying is violated. It's hard to see how it's not being violated.
We provided them with the right to strike. We've been in the process of bargaining process. They've stayed on 17% and they're not moving. We have already said, Tracian, we're not even close. We're 10% apart. And we're providing them with the way to exercise if they don't agree with what we do, and that is the right to strike.
Why was extending the framework agreement a few years ago good enough for your government then, and it's not good enough now?
We weren't at a 17% pay raise. Why is it appropriate for any bargaining unit in this province to put 17% on the table and not move? Because they know they can go to an arbitrator. What do I say to all those other hard-working Nova Scotians? We're suggesting, as the leader of the Conservative Party says, that we should provide everybody a 17% pay raise. That's just simply not sustainable.
I think the suggestion, sir, is whether or not you ought to honor an agreement that you signed with a party, not whether or not you don't like the fact that it might go to an arbitrator.
We've honored the agreement. What we've said is you have a right to strike. If you go back, if you go back and read.
Sir, the agreement doesn't give them the right to strike. Bill 203 will when it's law, and it's not law yet. They have the right to strike because you breached their contract.
Actually, right now they are in an illegal strike. That is the reality of today. We have a bill before the House that will provide them with a way to exercise if they disagree with how the contracts are going on. I would encourage them to get back to the table. But what we're talking about is 17% pay raise, and that is not sustainable.
Premier, if this is an illegal strike, what steps will the government take against the Crowns if you see this as an illegal strike?
Well, we're before the court today now. I believe it's gone into have an injunction to have it ceased.
When was that filed?
It was this afternoon, I think. I don't know the exact time.
Premier, you said to us yesterday you believe the bill will withstand a charter challenge, although we've yet to see a legal opinion on that. If you're so confident about that, why does your bill prohibit the Labour Board from ruling on the constitutionality of your bill?
We provided the bill that we believe provides fairness to the workers as well as to the taxpayers. And like all bills, we put it through the process.
Why do you think it's illegal?
Because right now there is no contract. There's nothing. The bill is not passed before the House.
Sorry, did you say that you filed an injunction to stop the strike?
Yeah, I think it went in. I don't know the exact time. I can get the time for you, but it was after lunch.
Premier, at least two cases today were tossed out of Nova Scotia court: an assault case and a drunk driving case. Who bears responsibility for that?
Listen, these are a professional group of men and women who I believe would ensure that those victims require the support of their services, that they would be in court to ensure that these cases are treated. It's my understanding Crowns were in court today. I don't know the circumstances to why they were released.
They were released because the judge would not agree to have the matter set over as the fill-in Crowns requested.
I believe there was also a case where the Crown actually was there at 11 o'clock in the morning, one of those cases, but I don't know all the details associated with it. But the reality of it is, I firmly believe that no one would suggest that it's more important to argue about a 17% pay raise than to ensure a victim of an assault has due representation.
Is your continued quoting of the raise that the Crowns are requesting meant to in fact distract from the fact that your government signed a contract a couple of years ago when it was convenient for you at that time, and now that some details of that contract no longer are, you're tearing it apart?
No, it's a 17% pay raise is unsustainable. That's exactly what I'm saying to you for. 1% across the entire public sector.
It's not for the entire public sector. We're talking about the Crowns.
You have a very different view than I do in collective bargaining. If you followed me over the last number of years, we don't treat public servants differently. We don't go into one group and say we're going to give you a 17% pay raise and then go to someone else and say, by the way, you're not worth that. How is that reasonable for anyone? That may be how other governments have done it. It has not happened since I've been here, nor will it be the case. I disagree wholeheartedly that this doesn't set a pattern.
Will
We
you
have a-
table the evidence and the legal argument you have backing that up? Because as you know, probably the most authoritative labor lawyer in this province disputes that this contract can set a pattern, nor has it in their previous agreements.
That is the same labor lawyer that uses previous contracts to negotiate new ones.
For thousands of employees,
starting in-
Premier, not hundreds.
With respect, we're not treating a group of 100 employees differently than a group of 10,000. You're a public servant in this province. We're going to treat you all the same. We're going to make sure that you've got a solid pension plan. We're going to make sure that we give you an appropriate pay raise. We're going to make sure that we can invest for the other 70% of the population. I get why the labor lawyer takes the position they do, because it gives them an advantage at the bargaining table the next go-around. I understand all of that. We traditionally, as a government, has continued to. What we offer one group of workers, we provide to all.
So why not go to arbitration? That doesn't mean they get 17%.
Well, the fact of the matter is, we have said all along, there has not been arbitration normally will end up finding it somewhere in the middle, which quite frankly, we can't sustain it. It's not sustainable. It's why we started out this bargaining. We went in and provided what we thought was a reasonable wage. It wasn't accepted. We went back then and started collapsing steps. So many of these crowns actually would start and getting an additional 4% increase. So for example, someone today, a new crown today was making $65,000. On signing this, they will have a new starting salary of $81,000. Over 80% of the crowns are making more than $100,000. We began to collapse steps there to them. The reality of it is that was sustainable for us. We cannot afford to allow someone else to set a pattern that we as a government continue to use when we negotiate with all of our unions.
But forgive me for going back to the previous question. If the province can't afford to allow a third party to set raises, why did you agree to an arbitration model in 2016?
At no time did anyone believe that someone would drop 17% and stay there. They, in essence, walked in with 17% and said, good, we'll go through this process, but by the way, we're going to arbitration. That is not free and open collective bargaining. They want another way to exercise, they disagree with us, we're providing that venue, which is the right to strike.
But why give someone a right if when they finally choose to exercise it, you don't like how they're choosing to do it?
The reality of it is, we need to make sure that all workers have an option when it comes to whether to deal with their employer. That is, in some cases, there are governments who believe arbitration is the way to go. We providing the right to strike.
The Crowns are staffing cases such as murder and sexual assault today, which I guess would fall under the definition of essential services. Why are you seeking an injunction today when the Crowns do seem to be staffing essential services?
Because that, quite frankly, is an illegal strike. So,
Okay, so you filed an injunction, the Crowns are still on strike, they're committed to staying on strike as long as possible. What's the next step? Are you pushing through Bill 203, are you doing back to work legislation?
I would say to you that the people who enforce the laws of this province will respect the laws of the province. Thank you all.